We're going to be talking during this section about how the juvenile justice process works. Some of the time I'll be referring to how the process works in Kentucky, since that is where our university is located, and the majority of the students taking this class live here. You need to understand, though, that every state has a slightly different process. Every state has to follow some basic rules, those rules that would assure that constitutional protections are in place. But other than assuring that those constitutional protections, and that's what's known as due process and equal protection, other than assuring that these protections are in place, the states have the freedom to create and follow whatever process they determine works best for them. The juvenile courts have evolved in the past 100 years, the first court being in 1899, so that they all follow a few basic rules. The idea that they are in the role of parens patriae, meaning standing in the role of the parent, which was the basic premise of the first juvenile court in Chicago. So let's ask the very first question that occurs in Kentucky. When a youth has a complaint that's filed against them, the very first thing that happens, even before a petition is filed in juvenile court, is the question of whether the child should be diverted away from the system. So the key concept here is the idea of diversion, and someone who is part of the court system, what's known as a court-designated worker in Kentucky, that person takes the referral and decides, should anything even be filed in juvenile court? In Kentucky, as long as the child doesn't commit a serious offense and it's their first time with a complaint being filed against them, it doesn't necessarily go straight to juvenile court. The administrative office of the courts, and that's the agency that houses the court staff workers. A staff worker will do an intake and determine if the child is eligible for diversion. So not all complaints against children go to the juvenile courts. The idea is that diversion diverts the child away from the courts. Now there can be a situation where a county attorney, and that would be the prosecutor who first sees the youth in Kentucky in district court, that prosecutor could petition directly to the court, but it's very rare for that to happen. If the youth has had several complaints already diverted, or if the offense is serious enough, meaning a felony, then that child probably won't be eligible for diversion, and the complaint moves forward to the juvenile courts. Let's say the case is not diverted. Then what? In Kentucky, there's what's known as a first appearance. And that means that the youth comes before the court and is advised as to what the charges are. At this point in time, in Kentucky, the courts will also do a detention hearing, meaning that they'll decide whether the child has to be locked up in a detention center pending the resolution of their court case. It might be a week before the case is resolved, it might be a month, or 2 months, or 6 months, or over a year. And I've seen many instances of youth who were in a detention center for a year or more when their case was pending. The length of time in detention just depends on the severity of the charges, the need to prepare an in-depth defense, and the attorneys that are on the case. Every now and then, I see counties in Kentucky too, where the juvenile court only sits on the bench once every 2 months. So these kinds of situations, these might lead a very simple case that could just take a week or two to resolve to take 3 or 4 months. If it's a serious case, which could be subject to adult court, the juvenile court in Kentucky will do a waiver hearing, sometimes called a fitness hearing in other states, because they are determining fitness of being handled as a juvenile or as an adult. At this waiver hearing, different factors are considered. In most states, the courts will consider the seriousness of the offense as well as the child's amenability to treatment, i.e., whether the child appears to be a child where treatment might bring about a change in their propensity to commit another crime, what's known as recidivism. So as we go through this course, this moment in time is sometimes referred to as the waiver hearing, and sometimes it's called a transfer hearing. They mean the same thing. And some states do what's known as a reverse waiver for serious offenses. This means if the case starts out not in juvenile court, but instead in adult court, and it is up to the child to prove that they should be treated as a juvenile. That's not the case in Kentucky, though. Children always start out in juvenile court and get transferred or waived up to adult court. To do a bit of a review on the process now, the starting point is some kind of complaint, often filed by a police officer, but it could also be filed by a member of the public. At that point, in Kentucky, the child could possibly be diverted away from the juvenile court by the court-designated worker. But if not diverted, then from the complaint, a juvenile petition is filed, and that is the real starting point for the child to be actually in juvenile court. The petition states what the nature of the complaint is against the child, and the child is commanded to appear in juvenile court to answer to the petition. An arrest warrant could also be issued, which means that rather than the parents taking the child to the court, the police have the power to arrest the child and place them in detention to come before the court. This will happen in serious cases, and if the police do take the child into custody, then the court has 48 hours to have a detention hearing to decide whether the child should be detained until their full hearing. In Kentucky, the factors for whether the child should be detained, meaning housed in a detention center or placement other than the home, that is determined by whether the child is a flight risk or a risk to public safety, or if the child is a risk to their own safety. Sometimes it's determined that detention is not needed, but some kind of security should be put in place, and the child is put on home detention with an ankle monitor, a tracking device that links to the phone and shows that the child has gone out of range if they get too far away. And some ankle monitors have GPS built into them as well, which will show exactly where the child has gone and at what time. Alternatives to detention are an important consideration at this time, because detention is expensive and in many ways detrimental to the child. This is particularly so for youth that are low-level offenders. They don't need to spend several weeks away from school, and even worse, spend time with other youth that are seriously delinquent. So all the states have what are known as ATD programs, meaning alternatives to detention. Every state also has a specific time frame in which they are supposed to do the detention hearing. In Kentucky, it's 48 hours, but that is if the youth is housed in a detention center. If for some reason there is no detention center available and the child got put in an adult jail pending their hearing, the time frame is expedited to 24 hours. And if the youth gets put in an adult jail, there are very strict guidelines of sight and sound separation. This means sight and sound separation from other adults. The states get serious fines for violating these requirements. And in Kentucky, it's very rare and pretty much unheard of for a youth to be inside a jail. Every county in Kentucky has a detention center where they can take the youth. In rural areas, several counties may be in what is known as a catchment area, meaning that one detention center serves many counties. But the point is, youth are rarely, if ever, taken to a jail. If for some reason the court does not get the detention hearing done within the time frame, the youth has to be released. And also, in Kentucky, if a child is in juvenile court, bail is not applicable. If they get waived to adult court, then they can ask for bail, but the juvenile courts don't utilize a bail system.